The views and opinions expressed on this show belong solely to the hosts and their guests and do not reflect the views of any outside institutions unless explicitly stated.
What's up, everyone? My name is Steve Vanderwall, and I'm the host of Cannabis Cum Laude, a podcast devoted entirely to cannabis. This podcast will cover a full spectrum of topics, including cultivation, business, medicine, politics, culture, advocacy, and everything in between. Because let's face it, the cannabis industry is very complicated. It's robust, and it has a ton of moving parts. So it's going to be my job to help you understand it a little bit better. So tune in every week for a brand new episode. And if you enjoy this podcast, please subscribe, rate, and review the show. And if you really like the show and are interested in sponsoring, please shoot me an email at logistics@cannabiscumlaude.com. Now enjoy the show. What's going on, everybody? Welcome back to another episode of Cannabis Cum Laude. I'm here today with two friends and two previous guests, Aleece Burgio of MJI Solutions and David Holland from Prince Lobel and the Executive Director of Empire State Normal. Two very prominent attorneys in the space. And today we're going to talk about some of the litigation and lawsuits that are happening in New York State that we're all pretty familiar with. And we're first going to talk about the most recent lawsuit. But before we do, just want to say thank you guys again for coming on the show. I know everyone's got a lot going on, especially in the legal space, but I do appreciate you taking a second to come on here and break all this kind of confusing stuff. There's a lot going on, and I'm hoping by the end of it, we all have a much clearer understanding of what's going on. So,
thanks for the opportunity.
Yeah, of course. Come on the show anytime. I love having you on here. Seriously, it really is a treat. So first, I want to talk about the most recent lawsuit that is happening from a group called the Coalition for Access to Regulated and Safe Cannabis. They are suing New York State. This is the second lawsuit that's happened in the past year. And let's kind of get an idea of who is this coalition? Who are the members of this coalition that's suing New York State?
Yeah, sure. So the coalition is comprised of 4 registered organizations. I think it's 3 potential general dispensaries out of New York City and some medical providers. So it's a newly formed coalition. I think that kind of came out right after regulations were dropped. And I think people were seeing how the rollout was happening. And it's being represented by Firestein Kulik, the law firm.
Okay. Now, there's a lot of firepower in, these RO coalitions. They have a lot of money. They have a lot of legal support. Why exactly are they suing New York State? And who exactly are they suing in particular?
Sure, Dave, you want to take that?
Sure. So the ROs, registered organizations, there are only 10 of them in New York, or there were 10 to start, and that number has been consolidated, but they are vertical monopolies. So they are able to cultivate their own product and sell it at retail to medical patients, and they're trying to make the conversion over into the regulated adult use market. So they have a genuine interest in trying to get that monopoly expanded out as quickly as possible. And what they have said, and their main criticism, along with the potential retailers that Aleece was just mentioning, is that the MRTA, the legalization statute, says that all applicants will be able to apply for licenses at the same time. And that is not what has happened, because there's been a group of conditional licenses issued across the chain from cultivators to processors. And we have what's known as the CARD program, or the Conditional Adult Use Retail Dispensary License. And that people have heard about, where it's somebody who's been previously convicted or justice impacted, as they say. It has the opportunity to get first shot at getting to a licensed facility that will be a turnkey in some circumstances, for the state has actually taken over the actual storefront and then leased it out to a provider. So their argument is that that's unfair. That's not allowing all applicants to the market at the same time. And that's the gist of where they're going. Aleece, please. I know you know so much about this, so please go.
So, well, it's the dispensary language is obviously very important in this respect because of how intense the zoning regulations are. So, for example, the regulations state that if depending upon the population in your locality, you're either going to need to be 1,000 or 2,000 feet away from another dispensary. So really it is first to enter the market has the foothold. And so when we talk about all dispensary licenses being opened at once per the MRTA, it's not necessarily that they couldn't have given licensed priority to these justice impacted individuals or women owned businesses or minority owned businesses, because that is language that's sufficient in the bill. The issue is that, because card wasn't really defined in the MRTA, giving them priority licensing, and then basically creating footholds in these areas, these geographic areas, which went from 150 dispensaries now to 300 dispensaries. So they doubled it in the last month or so, is where we ran into issues with this coalition. The coalition is saying this isn't fair. And so we haven't really heard a response yet. The complaint with the petition was submitted, but we haven't heard back from OCM, the defendant. They have until April 28th to respond. But it is an Article 78 proceeding, so it's a little bit different. It's in the Supreme Court of New York, in Albany, or in the Albany area. But it's a different proceeding than that, like say the Vericite case, which we'll talk about. It's usually a little bit more expedited. So we will see what kind of happens with this lawsuit rolling out.
Yeah, and let me just say one thing, because there has been some, issues of misnaming things. And so a lot of people have said, well, CARD is part of the social equity program. I don't see that it that way. Under the MRTA, there are 5 specific categories of people that qualify for social equity, which would be, people in the agricultural industry, women in minority-owned businesses, people that came from impacted neighborhoods, and there's disabled veterans. There's one other. And so the justice-involved individual is not per se identified as a special priority person, though they may have come from prioritized neighborhoods. So it's very complicated. As Aleece just pointed out, the CARD program, which one of the problems is, we don't know where the state has made arrangements or is entering into contracts to put up, state-sponsored storefronts. So therefore, having anybody go in as a private citizen that's waiting to go into the application process, which part and parcel, which you have to really put in a site plan and a security plan. We don't know where to tell people to go because we don't know where CARD's going to put their thing. And if there's 1,000-foot or 2,000-foot boundary, it's a real problematic thing. So while I am personally, and as a member of Prince Lobel and as a member of Normal, I can speak on their behalf saying we like the idea of the CARD program. I'm just not sure that it has all the legal footing to have been launched the way it was, and that there might be a legitimate claim there by the coalition about not everybody's being able to enter into the market at the same time.
There's also this issue of separation of powers. Okay, so as Dave pointed out earlier, there have been 3 conditional types of licenses. One's a cultivator, one's processors, and then these card license holders. The cultivators and the processors, the AUCCs, AUCPs, came in through a legislative process. They were formed through 2 bills. Okay. Now the CARD program was done through the regulatory process. Now the difference is when we put it through a legislative process, it's submitted in the Assembly and the Senate and it's voted on, and then it's signed by the governor. Now for this process, for the CARD process, and this is the argument from the petitioner, this is the argument from the coalition, that there was an expansion of powers done through the Office of Cannabis Management and the CCB through a regulatory process to, 1, create a new priority licensing category, and 2, not doing it through the legislator, as we've seen with the other conditionals. And so even though it was done through a public comment period and submitted that way, another argument made by the petitioner is that this was an expansion of powers and that it should have been done through the legislator.
So is it
one thing, sorry. Oh, go ahead.
No, you go ahead.
Sorry.
You go ahead.
I think one thing will be very interesting. We saw this a bit with the Trump administration, where you're supposed to have department heads and administrative heads are with the advice and consent of the Senate. And so therefore you saw he had a lot of acting heads of these departments. That was a way to bypass the advise and consent process. And so the question will be whether the state will, or OCM will take the position, these conditional licenses are not licenses, and therefore the applications for licenses are different than this temporary probationary license that is designed in the narrowest way possible to promote the interests of the state to try to redress the harms of the drug war and get those people that were most impacted to the most competitive positions without taking into account social equity or the other types of license applications that are out there that need to be spread across the entire populace to allow them to apply at the same time. So it'll be an interesting to see how they defend on that.
I think, the Office of Cannabis Management had the right idea. I just think that it was executed in a way that wasn't congruent, wasn't on the right. What I mean by this is CARD could easily have fit into that community who has been disproportionately impacted category based off the application. It was asking for an address, and they wanted to see what the median income was on that address. And there were a whole laundry list of things where I think the argument could be made that it is priority licensing. It's just kind of like subsections A, B, C in priority licensing, which regulations are allowed to expand upon. Law isn't going to have every single, period and T cross, because it's obviously something you get in, you get it approved, and then the regs are where you really get to the detail. I do think that the issue is that we brought in so many other parties to this game with CARD licensing, and specifically DASNY. So, this isn't a CARD license that just got priority licensing. They are tied to real estate, and they're also tied to a loan. Technically, I mean, the loan is definitely in flux right now, but the initial idea of a CARD license is that you were getting this loan from Office of Cannabis Management, from DASNY, that would assist with your real estate, your build out. They would enter into the lease with you. You would be a sublessor from DASNY, and they would help in facilitating the whole process, and you would have a loan directly with DASNY. Now, the issue was it was supposed to be a $200 million loan fund. And it just hasn't rolled out that way. And so really all they have is $50 million that was put in the budget last year that has, I think they maybe used less than $5 million of it so far. And so all of these people who are part of CARD, a lot of people who've applied with CARD knowing that they needed to have the loan in order to succeed, are now not getting that money anymore because they haven't been able to raise the fund. So, and that's as of today, that could very well change. They might be in talks of finding fund and what have you. But as of right now, that money is only in the 50 million guaranteed category. So, go ahead.
Well, I mean, but what you're saying is so important, and it's what makes New York so unique. It is becoming a market participant with its own people that's trying to, redress the harms of the drug war. So they're saying, we're going to provide you the space, we're going to provide you the money, and we're going to provide you first opportunity. Whether that follows in the spirit of the MRTA or actually comes out of the powers that are listed in it, that's a main, a cause for debate. But there can be no debate. New York is the most progressive and has truly embraced its own industry when it's putting its own money where its mouth is. I think it's just 100%. Fantastic. And you explained it so well, Lisa. Thank you for that.
You too, Dave. It's Dave hit the nail on the head too with it. It's very difficult to make comparative analysis right now with what New York is doing. Nobody's even close. I mean, Illinois was supposed to be the gold standard for social equity, and then they hadn't seen anybody that was a minority owned business owner for like 18 to 21 months or something like that. It's crazy. So they wanted to come out of the gate really, and they're not wrong. In order to really have a socially inclusive and equitable market, you have to have it right off the bat. It can't be, done with a lot of times with medical operators going first, or with, a massive general licensing and everyone gets awarded at once. Cannabis is first in. It always has been. You got to be the person at the starting line. And traditionally, we haven't seen social and equitable businesses, minority women at the starting line at the same time. And that's where problems have arisen. Yeah,
I mean, I definitely think that New York's head was in the right place, and they've, have done probably the best job at trying to create a socially equitable market. But the problem is that it is so complicated that we're now like almost 750 days since the MRTA passed, and we have this proliferation of unlicensed shops and unregulated shops that are now competing with the couple of, legal dispensaries. And, I think something like New York City, that's going to be a really tough thing to control, because it seems like I've been in New York City a couple times in the last month. There's a shop on every corner. Like that 1,000-foot rule, especially in New York City, is going to be tough to enforce. Rochester or smaller cities, you can get away with it. But I feel like New York City in particular is become an out of control animal. But I guess
you also have to remember too, half of the localities in the state of New York have opted out.
Yeah.
So we're only really dealing with half the state on where people can actually sell or on-site consume in this state. So this is a big issue. And actually Dave can speak to this because he was just quoted on this, but the Long Island awardance of 40 now card licenses is going to be almost impossible. So I don't know, Dave, you want to talk about that a little bit about just how that rolls out?
Yeah, it's extremely tough because there's only 5 towns in Suffolk County, which is the easternmost county out there, that have that did not opt out of the dispensary and social consumption type program. So, if you're going to have 1,000 feet and you're only at 5 towns, I don't think it's going to be an easy job to get even 10 of those people set up in those 5 towns, much less all 40. So I think we'll see reversals over time of municipalities that opted out, but it will have to be a campaign matter that will go back to general election unless they can call for a special election under their own rules. But all that is to say, it's a complicated area. New York City, while the municipalities, by the way, can ask for a reprieve from the 1,000-foot setback rule and can say, we think that there's a viable reason to have people closer together. And the OCM is looking forward to that. They were just trying to set a baseline so that people didn't feel that it was, it will be like every other, like Starbucks or something that has something on every corner too. But your point, Steve, is a good one. Right now, the unregulated market, there are 1,500 of them supposedly in the 5 boroughs of New York. The problem is, and history proves it, you can't arrest your way out of this problem. And you can't find your way out of this problem. So until you all of a sudden say, let's have 300 people go into, and what in a letter I'm proposing to OCM this week, and just off the record, is, with these illegal shops, you have landlords that clearly are disposed to wanting to rent to cannabis operators, simply kick out the illegal operators, and that can be done in a way that they don't get harmed dramatically. There's no criminal penalty. There's no tax consequence. They put in a card recipient or any other applicant and put them in, because you have a ready, willing, and able landlord, which is the hardest part, as Lisa's just pointing out. Finding somebody who will rent to the cannabis industry is impossible. You put them in New York City, you put 300 of them in. Now, all of a sudden, those 1,500 shops, there's a basis to go after them and really start to drive them out, whether it's going to be by the Department of Tax and Finance or the Sheriff's Department. That's a means of which enforcement agency wants to take it on. But now you have a business you're actually protecting. The 3 setup operators, I think the 4th one is due to open soon in New York City. That's all of New York City, a city of 8 million people. There's really no reason, or there's not a credible method by which you can go enforcing the law and kicking out the illegal operators when there's so few retailers to fill that void. So you're just gonna drive it back to the delivery services or something else. You're not going to get rid of the illegal business. What we need is a full onslaught of licensed operators that start to absorb that what was otherwise working in the illicit market. I think that's the only way to do it.
Well, and you got to think, my thoughts always go back to the licensed growers and processors. I mean, these hemp operators have been getting their teeth kicked in for the last couple of years, transitioned into cannabis thinking this was their golden ticket. And now you got 150 licensed farmers who now have 6th to 7th month crop out, which is, it has a finite shelf life, and there's 4 stores. So, do we see, If I was in that position, I would have and I was feeding my family that way, I'd have no choice but to be selling it out the back door, because all that work and all that crop and all that just to go to waste, I mean, that's food on your table. So I hope for the sake of the farmers and the processors, I mean, some of these, there's a processor in New York's, in Rochester right now, they put up like an $8 million facility, and they've been just sitting on it for months waiting for products to actually, have a place to sell. So, there's a lot of infrastructure in place and a lot of farmers in place that, with only a limited amount of legal stores, you're hurting a lot of these licenses. I'd be curious to see how many people actually renew their license or even grow next year, because I feel like a lot of these farmers aren't going to have, probably aren't going to have an end means, any place to sell their crop, with only 4 stores. But
think about this too with conditionals, right? So a lot of the conditional cultivators specifically are in upstate, our area, Buffalo, Rochester, Central, north of the city, right? And the big issue is the distribution component of the AUCCs, AUCPs is expiring soon. And a problem, and I know this firsthand for our growers and processors, is that they're having a difficult time facilitating a relationship, which we already know, facilitating relationships with people in New York City. It is a big feat, right? Because you're trying to make these connection points with these new card license holders to get your product in. There isn't that much differentiation between growers upstate that there is going to be overall, right? I mean, a lot of these guys have outdoor, sun grown, there's going to be varying levels of, I'm sure, different strains and things like that. But, it's not that, it's pretty even keeled on what they're selling. And a lot of these dispensaries are actually asking to go into processed form, right? They don't necessarily want flour on the shelves. They're looking for edibles, they're looking for oils, pens, things like that, because they are worried about the fact that it has been sitting for about 7 months, that flower. So the AUCCs, AUCPs have, they're being set up to like have a very difficult time finishing off what they were starting in May, which is getting their product on the shelves and being the first guys out there. If anything, they're making it seem like the product that should have been on shelves in September is, what we're seeing right now, which is delayed and it's expiring product, right? And so, a lot of these guys are about to hit the farm, in May, they're going to start planting again. And I totally agree with your assessment. They might say no. They might want to wait again and see how it rolls out and have maybe more dispensaries. Yeah. I also think, based off the regulations, a lot of these AUCCs are probably going to change their tier and change the type of way that they grow. Obviously with the conditional cultivators, they had to choose between being outdoor and being limited lighting for greenhouse. And you could mix greenhouse and outdoor, but you couldn't have any indoor. And it's the same thing that we're going to see. You can't have outdoor and indoor in the general. You can't have mixed light and outdoor, and indoor. So I'll be curious to see how many of these growers transition into an indoor license or a greenhouse license with more light deprivation. Because at the moment, I think they're really struggling to do outdoor in New York State. We're not California. We don't have the humidity and the climate that we've seen in the West Coast.
So let me just say this. You two have just raised such incredibly important points about some of the drawbacks the market exists. So for me, this suggests, and I'm only speaking for me, not Prince Labelle or Normal, but it suggests the exact insincerity of the coalition. Because while it has wannabe retailers, those would be a solution to the problems of the, conditional cultivators and processors. Allowing the registered organizations in do nothing except to actually increase the competition in a very limited market. And they can sell then to both the card applicants and their own retail operations, I believe. At a minimum, they're selling their own places. They have the money to get set up. So all you're doing is increasing their foothold in the monopoly. So I find that to be an insincere motive. And what I have is a problem against some of the registered organizations being allowed to come in at the same time as other applicants, because it's not a fair, level playing field that they enter into. And you pointed out the very reasons why that is.
Yeah, Dave, I think what we've seen, every lawyer I've spoken with who is closely paying attention to the regulations and how this is playing out in New York State, we all saw the writing on the wall with the ROs suing. This litigation wasn't a surprise. It's one of those things where, I mean, if the regulations essentially kind of rolled back what the MRTA was allowing for these ROs, which was an entrance into the market. It didn't say when, but it did say with a one-time fee, they could enter into the market, which obviously is very vague. And I think OCM could have capitalized on that, but it got expanded upon quite a bit with the regulations. It went from being a one-time fee to then every time you want to co-locate, it's another $3 million, and you have up to 3 times to do that. You can't really enter into the adult use space for 3 years. And then there's, if you do enter into it, you're going to have to divest all of your interests. And so it went from being, registered organizations can enter into this market to registered organizations can enter into this market with now a laundry list of 25 things. And I always think that there's a happy medium somewhere. I don't think that the ROs, given the way that the medical program, the way that we're handling it right now, I'm worried there isn't going to be a medical program because it just disincentivizes these 10 ROs from doing what they were initially licensed to do, which is keep a surviving medical program. We don't really have strong regulations right now that suggest to increase patient count, which is a problem right now because we just keep seeing a decrease in those numbers. And 2, for the ROs to keep putting out product if they're not seeing this opportunity to then enter into the adult use space in a realistic timeline and for a realistic price. So you have to kind of come and meet these people in the middle right now because it's going to take the OCM and the CCB, incentivizing patients to remain medical patients. And it's going to you have to incentivize the ROs to come to the middle here because as we've seen, these medical programs tend to fail once an adult use space rolls out. And we didn't have a very strong one to begin with. So the last thing you want to see is people who really need specific products and having a cheaper price to get them. 7% is a lot different than a 26%, 20. If we keep the wholesale tax, you go all the way up to, I think Jason Klimek said somewhere in the 40s. So it's important that we find some way to not totally isolate registered organizations, even though a lot of times in rollouts, they seem like the easiest scapegoat. But I think we got to play ball here because it's an important component of the space.
I would agree. And everybody likes to throw flack at the MSOs, myself included, and in some cases rightfully so. But I do think at this point, if it wasn't for, I think this is going to necessarily expedite this program. And, while there's always going to be cons to every situation, I think the pros in this situation is that it may open up general licensing a lot sooner than if they weren't involved. The problem with that is, even though it's good for somebody like me and anybody who wants a micro or anybody who wasn't involved in that first round of licensees, these people that were, these 150 farmers and these adult use processors who haven't been selling anything for the last year are all of a sudden going to be met with, all these brand new general licenses. Now, granted, it's going to take a while to build up and there's a whole timeline. But I do think, I think that the people who are already in the industry, I think it kind of hurts them. But I also think it provides, an open door for a lot of us who have been sitting around and waiting for licenses. And, I've been trying to plan for licensure for 3 years. And it's hard to make decisions when it comes to real estate and raising capital and building your team and hiring lawyers and consultants when there is no timeline. How do you, and there's a lot of people who've been paying on real estate for the last 3 years and paying their consultants. And at some point the coffers are going to drain dry. What do you think is the outcome of this? What do you think, how do you think this all plays out and what's it mean for the industry?
I think lawsuits are inevitable, right? We're going to see them and there's going to be more, right? It's not going to stay at 2. It's this year. We'll probably see a few more roll out here. I'm actually, frankly, more worried about Verisight than I am about the the coalition's case, simply because of just the way that the district court had basically stated in their ruling that they thought that the case had merit, independent of the granting of the preliminary injunction. So I'm worried about CARD being considered a constitutional law violation more so than I am, I think, this coalition case. I could be wrong, but Article 78 proceedings tend to be much more difficult to win. And typically, it's my understanding that usually they're not trying to completely impact a regulatory process, which allowing the ROs and allowing a general open would be a significant regulatory bump in the road. So I don't know. What do you think, Dave?
Yeah, it's funny. I come out on the exact opposite of where you are. Okay. On Vericite, I don't think that there's much of anything to that case. I think Judge Sharp, who is the federal district court judge who ruled on it, not somebody who has been pro-cannabis ever, from my personal experience in front of him. I think that he viewed the requirement of a New York conviction as being the requirement of a New York residency requirement on a historical basis. Mm-hmm. And I think that that's wrong. First of all, it was you can be an out-of-state resident, but you got to have certain ties to New York and everything else. The qualifying event was the New York cannabis-related conviction or arrest that ended in an alternative conviction like disorderly conduct. That's a qualifying event, not a residency event. And there's no way for New York to more narrowly, as they say, tailor the requirement to redress their goal of the MRTA, which is to have restorative justice for the harms done by the drug war. So I don't believe that they could ever succeed, and I'm surprised that it got this far. But I believe the Second Circuit Court of Appeals, which is the federal court that sits above the district court, will pretty readily straighten that out. So on the opposite of Aleece, in the coalition case, I think they have a good argument that, look, the CARD program is not anywhere to be found in the statute. And so therefore, this is agency rulemaking rather than legislative, directive. That said, I think that we'll see whether the state takes the position, but we can create conditional licenses and temporary solutions because all these are probationary. They're not, you're not guaranteed a permanent license if you're a card holder. You still got to go through the application process. I think they can argue, much like you were pointing out, Steve, and Aleece too. You have conditional cultivators and processors who are sitting on product going, literally rotting on the vine. There needs to be an immediate solution, and the ROs are not that solution because the ROs are not going to be required to buy from those people. So therefore, you've got to have retailers that are responsive to that market surplus. And that's where CARD comes in. And I think that to have opened up the entire licensing process, where you'd have tens of thousands of applications, would be too burdensome. So it was easier to say, let's pick this group of people with a prior conviction who have business experience. Only 900 applied, 300 are now granted the license. That will start to at least absorb the surplus. It's not a perfect solution, but I think it is a legally viable solution that I think will uphold. And I think the Article 78 will ultimately be dismissed by the coalition. But I think but as Aleece's concerns are, mine are just the exact opposite.
I do think that Plan C for OCM should just be to open up a general retail licensing and have CARD reapply through a general dispensary opening, and have a box that says, did you previously apply for a conditional adult use dispensary license? And personally, I think that mitigates all of Vericite and it mitigates the entire coalition lawsuit because you do open it up and hey, they can be as slow and prioritizing it as they want, which is why you can make the argument that CARD is part of priority licensing. But it does afford them the opportunity for a little leeway. You don't have to worry about these lawsuits. A lot of time lawsuits happen because people feel like they're being excluded. And so when you do open up a general window like that, it's not necessarily going to be as much as impactful with a lawsuit if you're a delayed possible applicant or possible license holder. And we're seeing that now. You're not seeing, let's put it this way. You had 900 applicants for CARD And so far, they're about to award another 100 at this next OCM meeting, allegedly. You're not seeing any of these potential card license holders suing because they haven't been awarded first, have you? Right. So I don't necessarily think you're going to see that many people start suing on a general application window if maybe they aren't the first person getting licensed, but they've applied for it. Now they're waiting for a possible license to come in. So I always think I always try to find the middle ground of where it can come in. And I even think that OCM can have a plan B, plan C, which is do some emergency regulations, open up a general window and allow people to start applying, because you don't need a real estate address. You don't need an address to apply. That's per the regs right now. So really all people need to apply with is their financials, community impact plan, energy plan, and that's basically it. And then
you're going to need site plan. I think you do need to be tethered to some location, because those have to be taken into account.
It doesn't happen until the provisional. It doesn't happen until after you're awarded. So you're awarded as an applicant, right? And then you have 12 months to finish your provisional license, where you do have a site plan. You do have all those things. So you could be awarded pursuant to this provisional license, which is then when you submit your real estate, you submit your site plan, you submit your security plans, all those things. So really just to apply, you don't need all those things.
True. I would just approve, but for me, practically speaking, I think that your chances of success are limited if you don't have some of these things nailed down.
Oh, no, totally agree. I just mean, like, if they had to do this at an expedited pace, you very well could. It wouldn't be outside the bounds of what's been written down.
I think that your solution's a good one. It also, then eliminates the problem of where is DASNY, the Dormitory Authority, planning on putting their places. Everybody's open now. The market's open to figure out real estate.
Market's open then. Yep.
Yeah. Then you can figure out.
I also think it takes the pressure off DASNY if they can't find the money, because that is going to be a huge issue. If the fund isn't secured.
Rumor has it they got it now, and then Governor Hochul's due to come out in an actual press announcement. But I wonder if I heard that rumor on the same day, just before the announcement of the lawsuit. We'll see. Again, New York's got the best of intentions, but the best laid plans of mice and men, right? It's they anticipate litigation. They're aware of it. I don't think they're afraid of it. Mm-hmm. But I would like to see, I think, Aleece, you're on it. There's a practical way. Let's just open it up, not because of the lawsuit. Let's just open it up because at least you can get as many applicants that are qualified as possible into the pool.
And you can still have card go first. You can still have those guys go first if that really is the priority that OCM is making their mission based on. But it also allows you to do minorities, do women, do disadvantaged farmers, do disabled veterans. I mean, we're getting a lot of pushback on these actual explicit priority groups, social equity groups in the law that have now been set, down the ladder with card going first. So,
and it drives revenue,
it drives revenue. Yep.
Faster the market, the faster the revenue.
Yeah. I was surprised they doubled down on card and didn't just open a window, but that's just my observation. I was very surprised that they went from 150 to 300, just given, I think, the comments surrounding card, and I think the difficulties for people that have been part of the program. But it all ties back to, you got to get stores out immediately, and that's the only way to fix the supply chain right now. Everything that we'll see in the next 2 years is going to be correcting the supply chain. That's when you really boil down to like a step one analysis. Yeah. We're struggling now because we have too much product. If we have, even 80 more stores come up in this year, you're going to have another problem, which is now the supply side on for general. So then that's going to be the issue, because now we're not going to have enough product, and we're not going to have enough processors. We're not going to have enough distributors, and let's hope that there's enough labs to suffice this state, because only, I think, 5 were awarded and 6 total have applied. And you got to hope that that's going to be enough for the scalability that we're talking about with this market, because that was it. That's all that applied, right? It's not like they're holding 900 apps and they took 300. They're awarding everybody who applied for laboratories. So that's an issue too that I think we're going to see. Micro businesses are going to be a very unique license structure. Also, I think based off the fact of how does the dispensary or where the micro cultivator processor is allowed to sell their product, if they're going to have to follow the exact same regulations as a dispensary does, because you're going to have a lot of difficulty finding, micro businesses are going to be able to find spaces that are in the same zoning requirements and things like that we're seeing on dispensaries. So,
you think they'll get a farm gate where they can sell right out of their facility where they're growing?
So I think they could, absolutely. Not in a town that doesn't allow retail or on-site. They won't be able to.
That's the problem, yeah.
That's the problem. I also think that they do have that opportunity to sell off-site, but I don't think micro businesses are realizing typically that means that you have to follow the path of a retail dispensary technically, which is you have to be 1,000 feet, 2,000 feet from another. You have to be 500 away from school, community facilities now as a new add-on to that. Away from a religious institution, so a place of worship. It's so limiting on where you can sell, and so some of the benefits of micros are going to be difficult to obtain if these places aren't selling probably out of where they're located.
Right. And I've actually had. So recently I've been shopping around for some warehouse space, and I actually found this awesome 5,000 square foot warehouse, industrial zoned, not a school or church or anything in sight. It checks every box. It's great. Big three-phase power, everything. Cool landlord. Problem is the one stipulation is there's absolutely no retail allowed on site. And maybe it's just this town. I don't know if that's how it goes with all industrial zone properties, but I feel like, because I've been looking for industrial zone, for commercial or for cultivation and manufacturing, if micro businesses are going to find that, okay, I found this great industrially zoned space, but now I have to find another retail space. And if it's in, the same municipality and they opted out, then you got to go to a different town. So I'm really kind of paying attention to the micro really closely. That's something that I've wanted since I started hearing language about it years ago. But I do think that it's going to be, finding that perfect property that's zoned for cultivation and manufacturing and allows retail. Those are kind of unicorn facilities, at least in my research. I've been on Zillow or LoopNet and all the, the real estate, sites for a year now, and finding that perfect property is challenging. There's plenty of retail available and there's plenty of, there's limited warehouse, but something that, will complement both of those, I think is going to be tough. And it's just, for a small business, affording the rent or buying two properties, that's not really feasible for everybody. So
the other thing is too with that is a lot of times you'll have to go for a special use permit on a building like that. So you would ask for a variance, and that requires public comment when you do things like that. And I can't tell you how many times we've seen when I was practicing out in Oregon, going for those variances and allowing the public to come in and pick, holes at why that's not a good location for retail. And it getting rejected. Yeah. So it does open the door for that type of anti-retail establishment out of the public, and it can be very problematic. So, it's going to be difficult. I think ideally they wanted it to mirror breweries and mirror on-site distilleries and things like that. I think it's going to be a lot harder than people anticipate, mostly because those spaces take big square footages and micros we're talking about small. So now you're even more so impacted. I think personally, there's a little bit more leeway when we're talking about large space.
Yeah. Well, guys, I real quick before we go, like a quick update on. So recently, Governor Hochul came out with this new enforcement proposal as a way to kind of curb this proliferating, unregulated, unlicensed shop problem that really is happening in every city, but really it's problematic in New York City just by sheer population density. Can you give us a quick rundown of what this proposal says and what it's trying to accomplish?
Sure. So there were two enforcement bills that were actually being looked at. There was one that was put in through the legislature earlier this month. Maybe it was back in January, actually. And then obviously the one by the governor, which had just dropped last week. The enforcement bill has been a debated topic in the legislature since last year when the bill died. There was a bill that died before the budget. And the problem really between the legislator and the communities is that they don't want additional criminal penalties. And Dave mentioned this early on. We don't want to have an enforcement bill that puts people back in jail when we're already starting to try to take them out or expunge any of these crimes that were marijuana related. The issue is this is a huge public. The public is on top of these illicit stores. Okay. So there's not just people in the community, in the cannabis community who are dealing with this. And at least on my end, I get asked this question constantly about illicit stores and why aren't they being shut down? And it's a problem because it doesn't really enforce the rollout of a legalized market. So it's an easy bipartisan issue to get an enforcement bill done because both sides of the line do want something to help promote a legalized market. Now, Governor Hochul's bill, basically the breakout is more of a tax and finance approach to shutting these stores down. You could be fined up to $10,000 a day, depending upon, how they're finding you. You could be fined up to $200,000 if you're also cultivating. And it would be really enforced by the Department of Tax and Finance more so than any other branch. OCM does have an enforcement team. It's not staffed very well. I think OCM in general is usually struggling to bring on more staff members to facilitate this rollout. But we'll see if the bill gets passed. It still has to go through the legislature, still has to be approved by the Assembly, approved by the Senate, and then re-signed by the governor. So I do think we will see some sort of enforcement happening just because of what a big public health issue this is. But I'm not sure if it's going to be the governor's bill or if we'll see it in a different format. That's just my take on it.
There had been, in addition to that, there had been talk in New York City about trying to go after the landlords that allowed these illegal operations to go. And I just, I don't think that that's a viable way to go. There are defenses to landlords that would say, look, the person showed me a CBD retailer license. They said they were selling cannabinoids. I didn't know they were selling THC. I don't know enough of the difference. And then the threat was, well, we'll fine them $1,000 a day for every day they allow that illegal operator to, use the premises. And that would strike me as unconstitutional under the U.S. Constitution's 8th Amendment as unreasonable fines clause, where, you're penalizing somebody disproportionately to the offense that they committed, particularly when they may have an innocent owner defense. So there's a lot that needs to be worked out here. But again, all these things are academic. Until you have the substitute legalized market to come in and displace the illicit market, this is just going to go on and on. And I think it's a foolish consistency, which will be the hobgoblin of little minds, to think that you're somehow going to come up with a magic solution when you only have 6 licensed operators in the entire state. You need to have a full force, as Aleece is suggesting, legalize it all, bring everybody in right now, let all the cards in and all the other applicants in. Do something, but you're going to have to displace. And displacement's not really the key. It's amnesty. You really need to bring in all the illegal operators that are allowed to now come out and say, I didn't own a successful business, which is what, a legitimate successful business, which is what CARD requires. But I was this person. I was legacy. I'm not just an opportunist who opened up a store. Yep. If you bring all those folks and absorb them, then you have the market has much less of competition than it has like in California, where you really have a 2-market system. Yeah. And New York's for New York to really be the progressive thought leader in the space, it needs to find a way to absorb, not to alienate the illicit market.
The issue is there's definitely, and Dave hit on that head, this differentiation between people capitalizing and having a brick and mortar and legacy operators. Yeah. And I get asked this question a lot, like, how do you differentiate? And it's a very, I think, subjective analysis. Probably all three of us might have a different opinion on how we separate the two. but even within the cannabis community, there's a big brawl out on that because legacy operators, people who don't have brick and mortars, are not happy with the way that these stores have been allowed to also just go and sell and have, not being checked when they've been living in fear for the last 2 decades, 3 decades. So it's a delicate balance in this space of how different groups are represented and how things can be impacted based off of, street credibility and what's happening and all these places. And I just think everybody should let's see how people do on a legalized market. And if it's not working out, it's not working out. But the illicit market is going to continue to be an argument for anybody who doesn't want to see this rollout play. It's an easy thing for them to bring up.
But New York has so made itself the proving ground for all those people who thought they understood how complicated the cannabis industry really was. And you're in the world's largest cannabis single consumption market. It is incredibly complex. It's incredibly striated. There are numerous issues that nobody took into account. So the brazenness that some people find in the gray market brings to light actually the realities of what that market was, both on legacy side, the opportunistic sides. And this is where I think you'll never see a greater learning environment in real time like you're watching in New York. And that's what's been so fun as somebody who's been doing this for about 30 years of advocacy, to see this all come up. And it is definitely, it's a quagmire on its best day. It's really fun because I've been watching this for decades and have always thought in my little, spare time, what would it look like to have a legalized market? Well, now everybody gets a chance to see that, and your opinions matter, and your criminal history matters. So it really makes it a fantastic learning ground, and people like Aleece coming into it, and others who have background experience, and the newcomers who ask the questions that us veterans have been doing this for too long forget to ask. It is really exciting, and to be on opportunities, Steve. You're one of the few people that has been an outspoken advocate for a long time and really done something about it and provided a forum for those of us that want to get to bigger audiences to talk about this. This show has been great, and I am so grateful every time you ask me to be part of it. So thank you.
I love having you guys on. Seriously, it is such a treat. I love talking to you both on air and off. You're truly, a wealth of knowledge. I mean, two of the best, and you've both been doing it a long time. Always so good to talk to you both. You always bring so much to the table, and I know my audience is really appreciative. So thanks again for coming on the show on such short notice. I'm sure this will be due for a follow-up in a couple months because it seems like there's always something new popping up in New York State cannabis, and I'm just so appreciative of all the work that you both are doing. Thank you so much.
Thanks to our friends here at Rockbox Recording and Production in Rochester, New York. They are a full professional podcast and video studio designed by a radio guy for podcasters. Audio, video, voiceovers, editing, whatever. Mouth off at Rockbox at rockbox.com.
You can follow Cannabis Cum Laude on LinkedIn and all other social media platforms, as well as Cannabis. And if you'd like to help support the show, search up Cannabis Cum Laude on Patreon. And of course, all of those links are in the show notes. Thanks for watching and listening.